Good afternoon. Miriam Ackerman for Mr. Temelkoski.
I just wanted to let you know that Mr. Rastusha took all your time. Proceed.
Well, I'd like 7 minutes of that time back for rebuttal, please, and I'll waive any self-imposed limits on questioning. As the 6 questions in this Court's leave grant suggest, there are multiple constitutional problems with requiring Mr. Temelkoski to register for life as a convicted sex offender when he was never convicted, but rather had his charges dismissed and his record sealed under the Holmes Youthful Trainee Act. The Court need not reach all of those questions. Any one of those arguments provides a basis to rule for Mr. Temelkoski. I'd like to concentrate on the due process arguments because they provide the narrowest and most straightforward path for this Court to resolve this case. A due process ruling for Mr. Temelkoski also makes it unnecessary for the Court to rule on other issues. There are 2 basic concepts of fairness that underlie Mr. Temelkoski's due process claims. First, the State made an express statutory promise to him in 1994, and he acted in reliance on what the statute said at the time. And it's fundamentally unfair for the State to renege on that statutory promise through retroactive legislation.
So you waived your free fire, so here we go. What you said here, the State made an express statutory promise and the defendant acted in reliance on that. So that's the first part doesn't bother me. The second part trips me up a little bit. I don't know. Well, let's start here. Was there a plea bargain in this case?
So the Holmes Youthful Trainee Act requires an individual to plead guilty.
Yeah.
So basically what the statute says, the statutory framework says this.
I know what the statute says. I'm sorry, I don't mean to cut you off, but we're probably going to run out of time because there are a lot of questions. So, but we don't have a case here where the defendant was told in like a Cubs plea, you'll get HIDTA status if you just plead guilty. Or do we?
We don't have a transcript, but I think that is a distraction because we have everything that we need to understand what happened here.
Okay.
The statute itself set out a promise, and that what the statute said is a dismissal under HIDTA is not a conviction for a crime.
Right.
It says a successful trainee, quote, shall not suffer a civil disability or loss of right or privilege, and it said upon dismissal the record, quote, shall be closed to public inspections. That's what the statute said.
That's a promise.
That's the statutory.
Statutes make promises?
I'm sorry, Your Honor.
Statutes make promises?
I think individuals can rely on the statutory framework. If I could point this Court to...
He was on probation at the very time the first SORA change was made, was it not?
He was on probation, but he...
So anytime during that period of probation, he's subject to changes that occur, isn't he?
Well, he's subject to changes in the terms of his probation, but he's not what he relied on occurred in 1994. That's when, so to give 2 examples, I think, from this Court's jurisprudence that might be helpful. One is this Court's case, People v. Stevenson. It was a case where this Court abrogated the year-and-a-day rule. The year-and-a-day rule basically said that if someone's going to be charged with murder, the victim has to have died within a year. Court said, we're abrogating that rule, but it looked at the defendant in that case and said, we can't apply that retroactively because when he pled guilty at the time, that rule existed. Another example is this Court's decision in People v. Gornbein, and in that case, the individual had been released on bail, and the Constitution was amended. The prosecutor sought and successfully sought revocation of that individual's bail on the grounds that he was no longer, under the new bail Constitution provisions, he wasn't entitled to bail. This Court said it's fundamentally unfair. What happened here, when he was released on bail, one set of, that statutory framework existed. It's fundamentally unfair to go back and change the rules. So in 1994, when he pled guilty, there was one statute in effect, and that statute said no civil disabilities. And we know from the record...
Pause for 1 moment. So when this is why I keep coming back to the plea agreement. It would make it a lot easier if you could just find me a plea agreement here. But I guess we don't know that there was one. We don't have some kind of Cobb's plea saying you will be admitted to HIDA status. So if that's not the case, when he pled guilty, he knew he was facing two different alternatives. One, the judge could, in his discretion, say, okay, I'm going to put you on HIDA status. The other one is the judge could find the plea was knowing and voluntary and say, no HIDA status for you, you're convicted. Now, if the judge had chosen option B, you're convicted, no HIDA status, now, unless we determine that SORA is punishment, bracket that, that's your other argument, the legislature could add SORA on as a civil consequence of his criminal conviction. Yes? I mean, if it's not punishment.
If the reason that the due process argument that we're making relies on the fact that he received HIDA, I think that's correct.
But when he pled guilty, you're saying he acted in reliance on this promise that was made to him. What I'm having trouble understanding is when he pled guilty, that's what he gave up. He gave up his constitutional right to jury trial. That's a big thing he gave up. In exchange for that, the government gave him a chance at HIDA or conviction in the judge's discretion. And so if the judge had chosen conviction, unless SORA is punishment, the civil penalty could be added on, no problem. So that's why I'm having trouble with the, he pled guilty because he knew that he wouldn't get the additional civil SORA penalties.
If the judge had denied HIDA, and we don't know if there was a Cobb's plea, if there had been a Cobb's, I mean, he presumably could have withdrawn his plea.
Does your client think there was a Cobb's plea? What did he say about that?
Our client believes, that he was going to get HIDA. That was his understanding. You can see from the record that there was in February of 1994, he was referred to probation.
But he's never said, somebody told me, the prosecutor told me there was a deal and I was going to get HIDA.
I think what's important here is this is really not about what happened with the prosecutor. This is about what the statute said at the time. And if I could
make it about what happened with the prosecutor, then we just have Santabello and we all go home. So if that factor in the record, we'd want to know that. But it's not, is what I'm getting. Okay.
We don't have a transcript, but we have everything we need, which is the statute and what he was ordered to do on probation. We know that he was granted HIDA. We know that he was required to do certain things in order to get that dismissal.
Yep.
It wasn't as if he didn't have to do additional things. He had to plead guilty, yes, but he also had to complete 3 years of probation successfully. He had to do educational programming. He had to pay fines. He had to do community service. He did all of those things. And I think I'd like to use the example from our brief.
You're overlooking one thing in support of your own position, which is I think that the very same day that he pleaded guilty, the court accepted him into HIDA. It happened in close conjunction. These things happen in close conjunction with each other.
They happened in close conjunction, and they happened after he was sent for a HIDA evaluation by the probation department, which strongly indicates that the probation department.
You're asking us to draw some chronological inferences from that sequence of events, which I don't think is unreasonable.
But what I'd like to emphasize, I'd like to take the comparison from our brief. If the state wanted to buy widgets, and Mr. Temelkoski said, the terms of the contract or the terms of the agreement with the state are, I will sell you widgets. The state will buy the widgets, but the widgets we have to first look at them and decide if we like them. If we don't like them, we're not going to buy them. And then if we do like them, then you got to produce perfect widgets for 3 years. If you produce the perfect widgets, then we'll pay you. So here, if the state had looked at Mr. Temelkoski's widgets and said, you know what, we don't like them, we're not going to buy them, that's like the judge saying, we're not going to do it, right? Then we wouldn't be here. If the state had said, if Mr. Temelkoski hadn't produced perfect widgets, if he'd messed up on probation, he wouldn't have gotten HIDA. But here, the state said, we like your widgets, and he got 3 years of really perfect widgets. Then the state can't say, you know what, we didn't really mean it. We liked your widget, you gave us perfect widgets, but we didn't mean it. We're going to go back, we're going to change what we said, what we promised. And so here, this is exactly what the state has done. It has gone back and said, you know, we induced you to do this thing, to plead guilty. We induced you to do well on probation, to do these things, and yet we are now going back and retroactively changing the rules.
What is the fundamental right to which the due process that you think is implicated in this case?
Well, I think there are a couple of things. One has to do with the rights that he gave up, the right to have a jury trial, all of the rights in the criminal justice system to confront one's accusers. The other thing is a state-created right. There are state-created rights, and here the state has created. The state would not have to have the Homes Youthful Trainee Act. It could decide not to do that, but what it can't do is create that and then take it away. So if the state
Why can't it? If it isn't, if taking it away is something a little more tendentious, it can't impinge on it, I think, is what you're saying. It didn't take away his HIDA status, but it certainly, in passing SORA, began to eat away at what he had hoped would be the protections of pleading under HIDA.
Well, I think if we look at what he was promised and what he got, we can see sort of what the distinctions are. So he was promised no civil disabilities. What he got was lifetime sex offender registration. He was promised that he would not be convicted. If you look at the registry website, he shows up as a, quote, convicted sex offender with a conviction.
But what is the fundamental right?
The fundamental right is that he gave up his rights within the criminal justice system in reliance.
So his plea is this is an assault on his waiver of his right to a jury trial.
It is a statutory promise that the state made, and he gave up
I don't think a statute's making promises, but go ahead.
He gave up his rights within the criminal justice system in reliance on what the statute said at the time. So to give an example, if the state said, you know what, we think that the age of height is too high. Let's from now on only have people who are 18 and younger get the HIDA. That the state can do that prospectively, but it can't turn around and say to everybody who is, you know, got HIDA when they were 19 or 20, we're going to now label you as convicted and put you on the Michigan sex offender registry. Those individuals pled guilty. They went through a diversion program. They did everything they were supposed to do on probation, and they got their charges dismissed. And so once the charges are dismissed, the state can't then label someone as something that they're not.
Well, he was a convicted sex offender under SORA. I understand it was a rather exotic interpretation of the law, but nonetheless, the legislature does have that authority, don't they?
I don't think the legislature has the authority to pass a statute. Well, if the legislature passed a statute that said that green is blue, that doesn't make it so. If the statute...
It does in Michigan.
If the legislature passed a statute that said...
Those people over there, if they said green is now blue?
If the legislature passed a statute
Not
that...
if blue was in the Constitution. Come on.
Okay, well, okay.
Stop it.
All right.
If the legislature passed a statute that said everybody who got HIDA when they were 19 and 20 years old in the past is now a convicted sex offender, we're going to put them on the Michigan State Police criminal history database and say that they have all the obligations, you know, all the responsibilities, all the consequences of someone who's convicted. We're still going to say that they're not convicted under HIDA, but we're going to say they're convicted for every other purpose. That does not make it.
Is that the, so, I mean, I have been round and round about this too, because it seems like, look, the legislature can't convict you. So, right, you can't be legislatively convicted. You would agree. The problem is, are you really convicted, or are they just using the word convicted? Like if the statute said instead of convicted means being assigned to a youthful trainee status, what if instead they had said everyone who was assigned to a youthful trainee status under section blah, blah, blah during this time period shall now be subject to SORA? I mean, is it just a trick that they're using, that we're getting fooled by, that they've used the words convicted, or is there something there? And if there is, I'd really like to know.
I think there's something there because of the way that the statute works in practice. I'd refer you to the letters that are attached to the Criminal Defense Attorneys of Michigan brief from individuals who are on the Homes Youthful Trainee Act who have similar experiences to Mr. Temelkoski. One of them, for example, describes how he got hauled in, he's a student at University of Michigan, he got hauled in for expulsion proceedings because on his application he had said, I've never been convicted. They said, you lied. You lied. You're on the sex offender registry. You're listed on the sex offender registry as a convicted sex offender. And he's not convicted. He didn't lie. But when the state holds someone out as convicted and they're not convicted, the public doesn't think, oh, convicted sex offender, this person doesn't have any criminal record. This person has their charges dismissed.
So you've described a harm, a real harm. I mean, I think that, probably if he had a trial for perjury, we would say he didn't have the intent to deceive when he said I was convicted, and so we would acquit him. The question is, those are all harms. The question is whether they're constitutionally cognizable harms that we can do something about.
I think they're constitutionally cognizable because of the way that, because in 1994, when he pled guilty, the statutory framework was what it was at the time, just like in Stevenson, just like in Gornbein. And so he pled guilty under a particular statutory framework, and the state later went back and changed that framework to be something different. And
okay,
that's.
But wait a minute. If he had, forget HIDA, doesn't exist. He just pleads guilty to the crime, and he gets convicted. If SORA isn't punishment, bracket that. I know that's your other argument. If SORA is just a civil penalty, can the legislature now say everyone who pled guilty or got convicted on the basis of a jury trial of a sex crime is now subject to SORA?
I think that there may be some additional issues but the basic question is, is the due process argument premised on him getting HIDA? And yes, it is. Right? The due process argument is premised on the fact. So
your argument has to be that the plea was induced by HIDA status as it stood at the time, even though when he pled, he knew that he might not get HIDA status, he might instead get a plain vanilla criminal conviction.
Right. This is going back to the widgets example. If the state's argument is, well, there's contingencies that could have happened. He could have been denied HIDA, and he could have, he could have had his HIDA revoked because he might have messed up on probation. But those contingencies didn't happen. And the contract, if we think about it in sort of in contractual terms, contingencies are part of contracts all the time, right? You make a promise. You make a promise contingent on certain things happening, contingent on him pleading guilty, contingent on the judge assigning him to HIDA, contingent on him actually performing on probation. So those contingencies, none of the things that could have avoided that statutory framework actually came to pass. And because all of those things fell into place, if he'd messed up, we wouldn't be here. If the judge had not assigned him to HIDA, we wouldn't be here. But
so we shouldn't. So I'm sorry, and I don't want to monopolize everybody's time.
Good, you're doing well.
If we think about the consideration here, not as his giving up his constitutional right to jury trial, although maybe that's part of his consideration, but the rest of the consideration is his performance of all the conditions of his probation. Does that help us? And so we say the government breached when his having done both of those things, given up his constitutional right to a jury trial in exchange for a chance to be put on HIDA, and then having been put on HIDA, he performed by completing all the terms of his probation. Now he has fully performed, and now the government did perform by dismissing his conviction, and now it's over. Like, contract fulfilled, done, nothing more can be done. If they wanted to put him on SORA, they'd have to do a new, give him more process, some new due process hearing, some civil proceeding or something.
I think that's absolutely right, Your Honor, because there are multiple things that have to happen. And just like the widgets, they have to like his widgets, he has to produce perfect widgets for 3 years, and that point, at the end of that, that's when you get paid, right? And you can't then at the end of the 3 years say, no what, we're not going to pay. I would also say that you point to something I think that's very important. This is not about whether or not the state can regulate people who have sex offenses. If you look at the language of HIDA, it says that you cannot, in 1994, you cannot impose a civil disability based on assignment to youthful trainee status. I can't remember exact words, but that's basically the language, right? So if the state said, you know what, Mr. Temelkoski is dangerous, we're going to have an individualized hearing, we're going to find that he's dangerous, they could absolutely impose SORA on him based on something else, on an individualized determination of dangerousness.
Yes, some separate proceeding now, today.
But they can't. What the HIDA statute said is you cannot do it because of assignment to youthful trainee status, and that's exactly why they've done it here, and that's why it violates due process.
Your argument with respect to the inducement, I want to see if I understand the theory. As you and Justice Larson were discussing it, as I hear you, you're saying it's a good deal more than the plea, although you're apparently conceding there was no prosecutor recommendation or some other way that the HIDA would have been binding. But the inducement's a good deal more than, the specter or chance of HIDA. It's that the defendant had a very good chance because he had been evaluated and knew by the time of the plea hearing that he was eligible and that the probation department was recommending HIDA. So that it wasn't just that there was a 5% or 10% chance. It may even have been in the defendant's mind more likely than not that he would receive HIDA. So I just want to know if this is your theory, that say his chances are something like 70-30. The defendant pleads guilty knowing, I have a 70% chance of HIDA and all of the benefits that come along with it. And furthermore, I think your position would be that had the defendant known at the time that he was potentially facing lifetime sex offender registry, that he may have been willing to take those chances if he knew that at the time. But if he, as opposed to going to trial and having no chance and if he's convicted of anything, being on automatically, I suppose. But I'm getting too hypothetical. But it's a little bit more than just I have a chance of being on HIDA, is it not?
I think it's more than more than the chance.
I have a chance that they'll go into this agreement and do the widgets. You're saying he had a pretty good idea that this is where things were headed.
But he had a good idea, and the fact is he did, the state did like his widgets. The state did, assign him to HIDA. It's not, if the judge had said, you know what, I look at this probation evaluation, I'm not convinced, he might well not have pled guilty, or he might have, moved to withdraw his plea. It's a little bit unclear because we don't have the transcript to know exactly what could have happened there. But the point is, if you look at the actual record, he had a probation evaluation for HIDA. He got HIDA, as Justice Markman said, exactly on the same day that he pled. And then he went on to do all the other things that were required of him. What the statute said is there's a couple of things that have to happen. You have to plea, the judge has to give you HIDA, and then you have to perform on probation. All of those things happen. So as Justice Larson said, all of the pieces have fallen into place. And at that point, that's when the state then has to, he's been accountable. He took responsibility. The state hasn't, though, fallen through. It hasn't taken responsibility or accountability for what it promised.
How do you account for Connecticut versus Doe, where the sex offenders argued that they were entitled to the expectation that they would not be exposed in the way that the SORA statute does?
So Connecticut is a procedural due process case, and there the court said that because individuals have been convicted, that there's no need for an individualized determination of dangerousness. It is a different issue here where the statute itself promised something different. So I think it's not really on point, Your Honor.
But there's no conviction here.
That's correct. There are dismissed charges. And all of the cases that the U.S. Supreme Court has, this is a critical point, Your Honor, all the cases that the Supreme Court has looked at on sex offender registration have dealt with individuals who have public, accurate conviction records. Mr. Temelkoski's record is not public. Describing him as convicted is not accurate, and he's not convicted. So none of the preconditions that are in any of the U.S. Supreme Court sex offender registration cases really apply here. And that's why this case is quite unusual, because you're dealing with dismissed charges. The Supreme Court has never said that you can regulate people based on a dismissed criminal charge. It has said that you can regulate, if the restraints are minor, you can regulate based on sort of using convictions as a proxy. But here there's no conviction to use as a proxy.
And I assume that we would attach double jeopardy significance to the dismissal here. I mean, it's not an acquittal, but
it's a dismissal with prejudice. So yes.
It is a dismissal with prejudice.
Yes,
yeah,
it is a
okay.
dismissal.
So is the problem that the state is trying to attach SORA penalties to a non-event? I don't even want to use the word penalty because that implies punishment. That's a different question. SORA consequences to a guilty plea on which judgment was never entered? Is that the problem? So you can't attach, if he had been criminally convicted either by plea or by jury trial and judgment was entered, we'd say, yeah, you're convicted, and now the state can attach civil whatever. But here, judgment was never entered, and therefore you're trying to peg some consequence to a non-event. It's like a hung jury. You're trying to attach a consequence to that thing that didn't happen.
Well, you're trying to attach a consequence to dismissed charges or to the fact that there was a plea and then later those charges were dismissed. And I think what's important is that this court can, certainly we'd welcome a broad ruling in our favor, but this court can also rule very narrowly, because the statute was changed, and the subsequent HIDA statute basically said no civil disabilities except for SORA, right? So there's a small category of people whose adjudications, who pled under HIDA many decades ago, over 2 decades ago, who fall into that sort of narrow category of
You have less than 3 minutes.
individuals.
You have less than 3 minutes.
I will stop. Thank you.
Good afternoon, Your Honors. May it please this honorable court. Julie Powell, appearing on behalf of the people of the state of Michigan and the Wayne County prosecutor, the Honorable Kim Elworthy. I will be sharing my time with Aaron Lindstrom, the Solicitor General for the state of Michigan.
You have to manage your time.
Mr. Lindstrom kindly loaned me his watch. Keep track of that. Whether analyzed as an ex post facto claim, a cruel and unusual punishment claim, or a due process claim, the Michigan legislature constitutionally concluded that requiring individuals convicted of certain sexually based offenses to register and report certain information to law enforcement and to make some of that information publicly accessible was rationally related to accomplish its express goals of prevention, protection from, and detection of future sex offenses. Just as it is this court's duty and province to say what the Constitution means, it is the duty and the province of the Michigan legislature to weigh competing interests, to make legislative findings and policy choices, and enact those policy choices into positive laws, particularly when those choices involve the safety, health, and welfare of the people they represent and from whom they derive their power and authority to govern. The Michigan legislature expressly declared its intent when it enacted SORA. MCL 28.721A provides that SORA was enacted pursuant to its police power with the intent to assist law enforcement and Michigan citizenry in the prevention and detection against sex offenses by convicted sex offenders. The Michigan legislature expressly found that a person convicted of committing a listed sexual offense poses potential serious menace and danger to the health, safety, morals, and welfare of the people, and particularly the children of the state. To protect against this potential serious menace, the legislature explained that SORA is intended to provide law enforcement and the citizenry with an appropriate, comprehensive, and effective means to monitor those persons who pose such a potential danger. Notably, because defendant successfully completed his HIDA assignment, he is exempted from the restrictions on residing, working, and living in student safety zones. Thus, he is only subject to the registration and reporting requirements, which are rationally related to the legislature's express goals of prevention, protection, and detection of sex offenses. Since its enactment in 1994, SORA has defined a guilty plea taken under HIDA assignment as a conviction. The legislature can define conviction differently for purposes of different statutes, and it did so in this case. The Michigan legislature clearly considered the competing policy interests here between giving youthful, albeit adult offenders a fresh start and protecting the public from sex offenders. They could make that policy choice, and they did. In fact, over the years, the legislature has amended SORA to provide for the removal of youthful offenders engaged in consensual sexual activity with similarly aged victims, and exempted most juvenile offenders from SORA. At the same time, the legislature has restricted HIDA assignment for youthful offenders who commit certain sexual offenses, especially those involving minors under 13 years old. When defendant appellant was 19 years old, he forcibly sexually assaulted a 12-year-old child. Because he waited nearly 20 years to litigate this issue and has failed to provide the transcripts of these proceedings, we do not know the exact basis of the defendant's factual plea. But at a minimum, we know that he pled guilty to touching a child under 13 on her vagina, buttocks, or breast for a sexual purpose or in a manner that was reasonably construed as being done for a sexual purpose. Notably, today, the defendant would be ineligible for HIDA assignment. A complete, correct analysis and application of Michigan and federal case law, combined with respect for jurisprudential principles involving separation of powers and state and federal sovereignty, compel the conclusion that requiring defendant to register as a sex offender and making some of this information publicly accessible was not punishment in the constitutional sense and does not violate the ex post facto clause, the 8th Amendment, or the due process clause. This court should affirm the Court of Appeals opinion. And with that, the people remain any remaining time that they have and stand for questions. Turning to Justice
Okay, I'll go.
Thank you.
So, yeah, okay. So here the defendant pled guilty. The plea was accepted. The judge said your plea is knowing and voluntary and there's factual basis and all the stuff that we require in a constitutional colloquy. So, and if the judge had entered judgment on that, we would say that's a perfectly adequate substitute for a constitutional jury trial. So, I guess your argument is all of that stuff, which is good stuff, right? He said I did this and it was knowing and voluntary and all of that, is sufficient to peg a collateral consequence to. Like because we have to narrow the field of people. We can't just say like everybody has to register, only certain people. And so your argument is that anybody who gave a constitutionally adequate guilty plea on which no judgment was entered, that's sufficient process, yes?
Yes, Justice Larson, that is correct.
So, okay, so now let me think about this. The trick is that judgment wasn't entered. And so I wonder about this case. Like, let's say the guy says, I want a jury trial, but he says, I want to take the stand, and he takes the stand and he testifies, and he says, yeah, I committed all the elements of the crime. And then like 7 other people show up and they say, yeah, we saw him, and they're all nuns. They're like perfectly credible, and they say, yeah, we saw it. And so like any rational jury would convict. And then it goes to the jury, and the jury hangs or they acquit, let's say they hang, so no judgment ever gets entered, and he doesn't get retried because the state, I don't know why. They got a really good case. I don't know why they don't retry him. But they don't. So now, could the state say, well, I mean, he didn't plead, but he confessed on the stand, and there were like 7 witnesses, and we believe him. No reason to dispute the fact that he did these things. So we're going to peg SORA to it? And why, and if not, why not? Because I'm trying to figure out whether the difference, like what's the difference? He wasn't convicted in his Haida, and my guy who went to jury trial, but the jury hung, he wasn't convicted either. But in both cases, I have a pretty good idea that he did the underlying events.
Well, in the situation where there was a hung jury and he was never tried again, you don't have a guilty plea entered there. Just because there's strong evidence that he was guilty would be insufficient. And the difference here is that the legislature, two differences actually. The legislature has defined conviction in different ways for different purposes, which they can do. So
yeah, I don't disagree with that.
For Haida, they said it's not considered a conviction if the defendant successfully completes his assigned Haida probation, right? But when they enacted SORA, they said, for purposes of SORA, a Haida disposition, meaning a guilty plea under oath, is a conviction, and they can do that. And the other point is that in this situation, defendant was still on Haida probation. He hadn't completed, if you will, the widgets yet, and so he, at that point, was not entitled to not have a conviction entered. And at the point when in fact, while he was still on Haida probation, was ordered to register as a sex offender. And at that point, he didn't say, oh, you know what? This negates a promise that I was made that induced my desire to plead guilty and waive all these important trial rights. He didn't say that. Nor did he say it in 1997 when he was still on probation and the information that he had been convicted, that he had pled guilty to a sex offense, became limited to, the public could go to the Michigan State Police at that point and ask to see information for convicted sex offenders. And at that point, he didn't say, whoa, wait a minute. You promised me I'm never going to have any civil regulatory consequences that stem from Haida. He never said that. And so that's the difference between the hypotheticals that you posed, Justice Larson. And that's, here, he pled guilty. And we would argue that he is not suffering a civil disability from his Haida assignment. He is suffering a civil regulatory consequence based on his guilty plea, which makes all the difference.
So what if this happened? So what if the judge is just forget Haida? I mean, it's just a regular criminal case, and the judge takes a guilty plea, does the knowing voluntary colloquy, says, yep, knowing, voluntary, factual basis, but I got a plane to catch, goes off on vacation, never enters judgment. So the guy's never convicted, and he's just like, yeah, see you later, I'm out of here. And he never gets convicted and he never gets sentenced. Could the legislature say, oh, but you pled guilty to a sex crime, so I'm going to attach a collateral consequence to it? Judgment was never entered. It's just a plain, ordinary guilty plea. Well, but the judge never entered judgment because he went on vacation, and so there was no judgment, no sentence. But there's a guilty plea that was knowing and voluntary, et cetera.
Well, in that situation, the judgment wouldn't actually enter until he was sentenced anyways. So if no judgment of conviction had ever been entered or no order of probation, then no, the legislature could not attach a consequence to that.
Why is it the guilty plea that does all the work? What does the work?
Well, what does the work in the situation is the legislature's ability to define conviction differently for different purposes, and their ability to attach civil consequences to that. Now, Justice McCormick, in this situation, when the defendant was ordered to register as a sex offender, he was still on probation. And at that point, he had not fulfilled the terms of his Haida assignment where no conviction had not entered yet. So the legislature could consistently say, you have to register as a sex offender. He did register as a sex offender, and he did it.
But once the probation is ended, okay, so he suffers the disability, the first disability of the new SORA Act during his probation. Once the probation has been completed and his case is essentially a sponge, how then does the legislature continue to be able to suck him into the successive SORA and more exacting SORA changes?
Well, Chief Justice Young, SORA itself, ever since its enactment, has said that for purposes of having to have this civil regulatory consequence of sex offender registration, you have to be convicted of a listed offense.
But that's the kind of the trick here, isn't it? Yes, he pled guilty, and then it was dismissed and expunged or placed under seal, the equivalent of it.
Well,
And the reason he did all the probation stuff is so that it would get dismissed.
Well, and he did get what he bargained for. He did get what, and I agree with Chief Justice Young that statutes can't make promises, but what the HIDA statute in effect said that if you complete A, B, C, and D, then you will have your fingerprints returned, you will have your case sealed, and it will not be open to public inspection, and you will not have a conviction. And for every other purpose except for sex offender registration, he does not have a conviction. He could fill out an employment application and truthfully answer, and I believe, Justice Larson, you used the example of perjury. If he was asked about this question under oath, he could honestly answer, I do not have a conviction. I do not have a criminal conviction. I have never been convicted of a crime.
But don't you think that's a little bit complicated in the sense that he could say he doesn't have a conviction, but then people can find his picture on the internet as a sex offender on the registry where it actually tells people to tell a friend to look at this? I mean, I just think that's really is that a really genuine argument? The idea that the person's on this list as a sex offender, but then when they go for a job, they go to rent an apartment, they go to do any of the basic things that we would do in civil society, it's going to come up that they're a sex offender. So how do you correlate that?
Well, Justice Bernstein, it is the information, first of all, the Michigan Sex Offender Registry, they talk about that people could be convicted for different reasons, and they exhort people who who choose to go and access the public registry to verify the information on there, to make sure that they have the right person, to verify the accuracy of that information.
But if I'm this individual, what I'm trying to understand from you is, so what do I tell an employer? I'm in the interview right now, I'm just trying to understand. So you're saying there's no disability, so what do you share with an employer? I'm on the sex offender registry list, but I'm not convicted of a sex crime. How does that work?
Well, you don't have to tell a defendant like Mr. Temelkoski could tell any employer that he's never been convicted of a crime.
And when they Google it and it comes up, what's his response? I've never been convicted, but I'm on the list?
Well, his response is that I was 19 years old and I received a special consideration from the state because of my youthful offender status, and that he could be honest and explain it to him. And the whole purpose of sex offender registration statutes is to protect the public and to empower parents and employers to decide whether or not they want to let people who've been convicted of listed sex offenses to have access to their children.
I don't know whether this court has any authority to enforce governmental integrity, but you would certainly agree that that tactic doesn't seem to be in accord with the standard of governmental integrity, do you? Characterizing things in that way. Why not call him a murderer? Why not go all the way and call him a murderer?
Well, Justice Markman, he's not a murderer. He never pled guilty to committing murder. There's not, if the legislature enacted
Pleading guilty doesn't transform one into a criminal or a felon of any sort, does it?
Well, it does if you plead guilty and you're sentenced. He pled guilty and was given the grace of HIDA assignment. And if he had failed to complete his HIDA assignment, the conviction would have entered, and then there's no question that he'd be forced to register as a sex offender.
It seems to me he was opposed to the full measure of public obloquy that applies when somebody is convicted of actually being a sex offender. The only question in my mind is whether there's any kind of constitutional remedy, or indeed whether it's constitutionally relevant that he was exposed to that very same measure of obloquy as if he had been a convicted sex offender.
Well, first of all, Your Honor, the people would submit that he is a convicted sex offender for purposes of the sex offender registry, which is a civil regulatory scheme, and the legislature can define convicted in different ways.
Why can't it define convicted as somebody who's acquitted of a crime then?
Because that would violate the double jeopardy clause, Your Honor. That would violate an explicit...
Well, you don't want to say that. If you say that, then you're conceding its punishment. You don't want to do that, do you?
No, I'm not. The question, with all due respect, Justice Larson, was what if the legislature defined convicted as somebody who was acquitted of a crime?
Yeah.
Mr. Temelkoski was not acquitted of a crime here.
I know, but I thought your answer was if he had
If the
been...
legislature said conviction means acquitted of a crime, they couldn't say that because that would blatantly violate the Fifth Amendment of the United States Constitution.
Well, not if all
If
they
it's not a
mean
crime.
is we're going to attach civil consequences, not criminal consequences, but only civil
Okay, here's
consequences
the
to
way
your
it goes.
acquittal.
SORA, a non-punitive civil penalty, is defining your liability on the basis of a crime you have been
You were acquitted. But you
acquitted
were
from.
charged. You were definitely charged.
Charged but acquitted, but for the purposes of SORA, we're defining those acts, acquittals, as being convictions under SORA.
But the difference here, Your Honors, is that the defendant was not acquitted of a crime. He was not. The legislature doesn't. The legislature
doesn't have a judgment of conviction either.
But he pled guilty, Your Honor.
Yeah.
That makes it
That's what
different
we're trying to
than.
figure
Please
out.
engage the hypothetical, because that's how we test the limits of what you're saying. You know what I mean?
Right.
It's not helpful to us to say that's not this case. We know that. We're trying to sort out the boundaries of the proposition you're advocating.
I understand, Justice McCormick, but
So
I
why
think.
couldn't the legislature say he was charged, he was acquitted, but friggin' Wayne County juries, we know what they do. Like, he was charged, there's good evidence.
Good enough for us,
We're defining that as a
SORA.
conviction for SORA regulatory purposes.
Well, I think that there is a fundamental difference between the hypothetical posed that makes all the difference in this case.
Well, tell
And-
me what that is, because
Okay.
look, I'm not trying to confuse the situation. I'm trying to understand why it is permissible for the government to define, for the purposes of, to be consistent, a civil, non-punitive remedy, to define something idiosyncratically, something that didn't happen over here.
Okay. The difference is, with the hypothetical that you posed,
Yes.
is that with a situation where the defendant is acquitted, there is no factual admission of guilt. Here, the defendant has given up some of his rights.
Well, suppose there was a factual admission of guilt and there was a technical violation and the confession was thrown out.
Well,
That's what I was trying to do with my
difference is
confession hypothetical.
The technicality of the Constitution?
Yeah,
Okay.
that's right.
Right.
the difference here is that the
Well, we
defendant.
were talking about whether there's a confession or not. There's a confession, but it isn't binding. It isn't effective.
This is different. A
It's
guilty
not a
plea
confession,
is.
it's a guilty plea.
A
Right.
guilty plea is fundamentally different than a confession. I mean, a defendant could confess to a crime. It could be on videotape. It could be like high definition, the new high definition television that looks like you're right there. There could be no question that he was guilty, and the state would still have to go to trial and prove beyond a reasonable doubt every element of the crime. Here, defendant gave up his constitutional rights in exchange for the hope of HIDA assignment. There's nothing in the record here to indicate that he was induced to plead guilty by the HIDA assignment. And he raised his right hand, and he gave up his rights, and he pled guilty. He said, I committed this crime by doing the elements of the crime here. And he said, he gave all that up, and if he had not successfully completed HIDA, then that would have been a conviction that entered. And the thing here is, even if we want to say that SORA registration rendered his plea involuntary somehow, the remedy is not that he is exempt from all civil regulatory consequences. It would be withdrawal of his plea, and he has never moved to withdraw his plea.
He's not exempt from all the civil penalties. Is that what you said?
It is, Your Honor.
Isn't that what HIDA promised? Isn't that what HIDA said at the time? He would be exempt from all civil.
HIDA said that, it didn't say that, Judge. It said, I'm sorry, it didn't say that, Chief Justice Young. It said that he would be, upon successful completion of HIDA, he would be exempt from civil disabilities related to his HIDA assignment. And there's no proof that that's what induced it. And the thing,
we're not talking about whether he was induced. I'm just trying to
right.
understand. He was, the statute at the time under which he was committed, the HIDA, told him that he would not have civil disabilities.
If he successfully completed
Right.
HIDA. That's correct, Your Honor.
And what the subsequent amendments of SORA did was create additional civil disabilities.
That's correct, Your Honor, and it created civil disabilities while he was still on HIDA assignment, and he knew that he was subjected to those assignments, including the public disclosure of certain information. And so that all happened while he was still on probation, before his HIDA assignment was completed and before he received all the other guarantees that he was entitled to from his HIDA assignment. Now, this case reminds me a little bit of the deportation cases where the U.S. Supreme Court said that if a defendant was not told as a component of effective assistance of counsel that he could be deported, he would be allowed to withdraw his guilty plea. So even there, with deportation cases, a person can be deported even if they have HIDA assignment, even if there is no conviction entered. They can be deported even if they have a 7411 disposition where no conviction enters. So even there, when a conviction does not enter, they are subjected to civil regulatory consequences like deportation. They're not exempted from that.
But they have a right to know about those consequences before they plead guilty, correct?
And if they don't know about the consequence, Justice Viviano, then the remedy is they get to withdraw their plea. They don't get to be exempt from deportation.
Well, and they don't have to know about all civil consequences.
That's correct.
There's no requirement to advise about everything.
That's correct, and I think that
It's just that the statute said on this particular one you won't have civil disabilities. But your best argument is, I think, that there's nothing in this record to suggest that not being exposed to civil consequences, including SORA, was important to this defendant, that thing induced his plea. We have no reason to believe that he pled to avoid SORA.
well, and Judge, I think that the record...
Is that right? Is that...
Justice Larson, that is correct, because, you know, maybe there's a different argument here if the defendant didn't learn about any of this, and maybe there's a better argument for defendant. I still think he would have to register under SORA, but this defendant did know he was going to have to plead.
Did you plan to share?
Yes, I did, Chief Justice.
Currently not.
Beg your pardon?
Currently not. You're under 5 minutes now.
Oh, come on, I want to hear from Aaron.
You do?
Oh, I do. Because I want to hear what's going on. It's a hard case.
Yeah. You only get 4 minutes, though.
Sorry.
I'm sorry, Justice Larson.
No, go ahead.
Are you going to share or not?
Yes, I am going to share. I'm sorry,
Well,
Chief
then
Justice.
you have to stop.
I think he's suggesting that we should hear from Mr.
Oh,
Larson.
okay.
Justice Larson speaks Chief Justice Young language, so she can translate.
Thank you.
Special-
I need lots of help.
Good afternoon, may it please the court. The pleading guilty in this case is a significant legal event that attached, if you view this as a contract case, which I think I'd like to say why it's not, but if you do view it as a contract case, that pleading guilty had significant consequences. The legislature set it as a trigger for even being eligible for HIDA status, And then there were a lot of benefits, the freedom from double jeopardy that could arise later that you raised earlier, the fact that he didn't go to prison, the fact that he doesn't have to qualify under SORA for the residency or all of those three things are no longer at issue in this case because he's exempt from them. He also had no consequences for the sentencing enhancement from other crimes. The fact that he was not convicted means he's not going to get a sentencing enhancement if he gets another crime. He's allowed to carry a gun. There's just a number of consequences that he benefited from if you view this as a contract case. But I would also say that a statute doesn't create a promise. The theory for that to work would have to be that the 1994 legislature could make a promise that binded the 1997 legislature, for example, which is contrary to Studier, which says one legislature cannot bind a future legislature, and that there's a strong presumption against treating any statute as a contract. And that's particularly applicable here, where there's a readily available mechanism for entering into a contract, which is a plea agreement. And the plea agreement is specifically not at issue in this case. They have conceded in their reply brief at page 6, reply to the AG's brief, that they're not relying on anything, any promise outside of the statute. So to the extent that this is being viewed as a contract case, I think that's fundamentally wrong. There's an expectation, there's a hope, but the legislature has the authority to change the rules. That's what the legislature exists for. It sets policies. It doesn't enter into contracts, and those policies have to change over time. That was this court's reasoning again in the Studier case.
That was quick.
I have more to go on. I just
well,
thought it looked like somebody was going to ask a question, so I was trying to provide a break in case somebody wanted to.
They're pretty good at breaking in if they want. Oh,
Fair enough.
There it goes.
No, I was just going to suggest, you know as well as anybody that there are many areas of the law, however, in which after the fact, ex post facto, retroactive applications
Correct.
are looked upon with some suspicion and some kind of
Absolutely.
sense of jaundice. And whether this is one of those areas or not, I guess we'll leave to our further discussions. But
Well, that ties into the ex post facto distinction. If it's only a civil effect, then that's resolved under the due process clause. If it rises to the level of being punishment, then you'd analyze it under the ex post facto clause. And they can't add punishments, I agree with that. But they can add retroactive civil consequences. That's what the distinction is about between the ex post facto clause and the due process clause.
What's wrong with Doe versus Snyder?
Doe versus Snyder is wrong on a number of levels. It's inconsistent with a large number of other circuits, at least 5 on the registration issue, 4 or 5 different ones on the school safety zones issue, for example. So we are taking a cert petition and we're challenging that case. We're in the process of doing that now. So there's a number of mistakes. The banishment mistake, which is not at issue in this case, because he's conceded that that doesn't apply. Banishment, you have to think about what level of generality you'd look at, and it's not clear to me why you'd pick the city level instead of the state level when you're looking at the effect of a state law. So that's one example. In Grand Rapids, for example, if you look at the map in the Doe's case, there's lots of neighboring neighborhoods that are left out where somebody could live. There are lots of places in Michigan where someone can live and work without being 1,000 feet of a school.
But that's not an issue in this case.
It's not an issue in this case. It's only about the Doe case in the Sixth Circuit. And I see my lights on, but I'd be happy to entertain any more questions.
Nope, you only got 4 minutes.
Thank you, Your Honor.
Thank you.
The state says that the plea was a significant event, and I think it's important, therefore, to look at what he knew at the time of the plea. He knew that there was a law that said the Homeless Youth Training Act that promised him no civil disabilities. He knew that he had been evaluated for HIDA. We don't know for sure whether he knew that he was being promised HIDA. We don't know that because the record doesn't exist, but he knew that that law existed. What he didn't know was that 22 years later, he would be branded as a convicted sex offender. He did not know that he would have to report in person every 3 months for the rest of his life. He did not know that if he wanted to take a family vacation to the Grand Canyon, he would have to report in person beforehand, before he went, and when he got there, he wouldn't be able to rent a car because he'd have to go back and report in person within 3 days, and you can't do that during a week's vacation. He didn't know any of those things. He didn't know that he had to report in person within 3 days if he started to borrow a telephone. All of those things he did not know. He was entitled to believe in the law that existed at the time, and if we look at the plea as a significant event, we have to look at notice, we have to look at voluntariness, and we have to understand that the consequences that he thought he was going to get are fundamentally different from what he ended up with. He ended up with a situation...
Why is it fundamental in a constitution sense?
Because I think the plea has to be voluntary and knowing, and these are very, very severe consequences that they're saying they can attach not to a conviction, but to dismissed criminal charges. But they're saying they can attach it to a plea, but that plea had no knowledge of what these consequences would be. And so I think that is an additional basis why this violates due process.
Do you want to summarize what your thoughts might be on the U.S. Supreme Court's decision in Santabello versus New York?
So Santabello is a plea case, and it basically says that you get specific performance. I mean, the state has to abide by the terms of the plea agreements that it makes. There was a comment earlier about plea withdrawal as a remedy. I'm not sure how you withdraw a plea in a case that's already been dismissed with prejudice. It seems procedurally very complicated. It seems like it raises double jeopardy concerns. But in any event, if you think about this as a plea bargain case, right, as in that contractual terms, Santabello and other cases from this court as well, and they're cited in our brief, say that it's really the defendant's preference is important, and you have to look at what's equitable here. He's already completed everything that he was supposed to do. It's the state that hasn't done what it's supposed to do, and so specific performance, if you think about it in those terms, is the appropriate remedy here rather than plea withdrawal.
It does stand for the proposition that we can give consideration to the nature of the inducement or consideration offered in the course of that plea, and that to some extent that promise is deserving of being fulfilled, right?
That promise absolutely is deserving of being fulfilled. He was promised no civil disabilities. He was promised no conviction. He didn't get that.
He was promised by the statute?
He wasn't necessarily promised no conviction. That's the problem for your case. The problem for your case is that he entered his plea, and when he entered his guilty plea, he knew the judge could either say, I'm going to give you HIDA, and then you get all this stuff, or I'm going to just convict you right now. And then you've got a conviction, and then unless it's punishment, there's no problem with him being on SORA.
He knew that he might fail on probation. But again, if we go back to the widgets.
Or the judge might not even assign him to HIDA status.
Or the judge might not assign him to HIDA status. If that were the case, this argument, we wouldn't be having this discussion. But it's like it's sort of a contract. You could think about it as a contract with conditions. And if the state holds out this promise, if you do these things, if you plead guilty, and if the judge likes you, and if you complete probation, then no civil disabilities, no conviction. And all of those things happen. The state holds out the promise. He pleads guilty. The judge says, yep, I agree. You look like you're likely to be rehabilitated. And in fact, he has been. It's been 20 years, no subsequent sex offense. All three of those things, and then he completes probation. At that point, that's when the promise becomes due at the end. And he didn't get what the state promised him.
Thank you.
Thank you, Your Honor.
Case is submitted.